Hello and welcome to Legalese. My name is Vincent Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show is a panel discussion on common mistakes made by clients. Our panel consists of attorneys Bill Jones of the Jones Law Firm as well as attorney Angela Lawson of the law offices of J. Vincent Perryman. I thank you both for being here today, and I think we've got a pretty good range of experience between the three of us. Bill, you've been practicing for a while as well as I have, and Angela, you're relatively new to the practice of law, but we all have practiced long enough to understand that when clients come to us, sometimes they've already shot themselves in the foot. And that's the purpose of discussing this today, is just in a general standpoint of some things that people need to think about before they do.
Sure.
So,
we can't pick our clients. They kind of come to us in the various states, and throughout the years, I think we've all seen clients that come to us, and they have done themselves no favors in the months or years leading up to when they decided to come to us. I know that your practice is a little bit different than mine. You focus mainly on tax issues and
transactional stuff and probate, estate planning, those things. And then Angela with us does a lot of general litigation as well.
Right. So you probably see more family law like I do, and that's definitely something that emotions are generally high. Not to say that they aren't when the IRS is involved. But there's definitely animosity that you're dealing with, and I guess one of the first mistakes that my office sees when somebody comes in is pointing the other finger at somebody when they really need to take a long, hard look at themselves first. Mm-hmm. An example of this would be anything from text messages. They're a killer in this day and age. And you always get the clients that want to show you their phone that says, well, he sent me this text message that said, get hit by a truck and this and this. And as the attorney, nine out of 10 times when I say, okay, may I see your phone? There's that hesitation. It's, oh no, I don't want you to see the things that I've sent him that, mm-hmm. that are just as bad. I just want you to look at this stuff. We were talking before the show. I think the other thing is drug testing, mm-hmm. alcohol, things of that nature. We're seeing folks come in, you need to go into court and you need to drug test this person. Well, when that happens, most of the time the court is going to ask for both parties to be tested. And more often than not, when you're in a relationship like that, if one party's doing it, the other either has knowledge or they've mm-hmm. dived in with them.
Right, yeah, we had a case like that where we've seen, clients that come in and they, make accusations of this, and then when you'd say, okay, well, what about you? Would you pass the test? And like, oh no. So it's like, okay, well, she's on the other foot in that case. So.
I think that the overall point is the first mistake that comes to my mind is make sure that your own affairs are in order mm-hmm. before we start going after the other guy.
Well, and I think one thing with this is a lot of times if we go back to the lessons we should have learned in kindergarten as far as think before you speak, a lot of folks, especially when you're in something that could go into litigation or go into some sort of controversy, clients and just human nature, you don't think before you speak. You let your emotions take control. You say something that you didn't necessarily mean, and it gets taken out of context, or maybe it gets taken in context, but your emotional state wasn't rational at the time. That's a huge factor, whether that be with divorce, general litigation, a collection matter, talking to a debt collector, or even talking to an IRS agent, you know.
And I think that brings another great mistake that springs to my mind, and that is use your common sense. I think what we see often than not, we were all told the same thing in law school, and that's when a client comes to you and they say, I don't care about the money. This is the principle of the matter. that when a client comes to you and says it's the principle of the matter, you should run or triple your retainer, one of the two. Because most of the time when you've got somebody and they're fighting for just the principle of the matter, they're not thinking rationally. They're not doing a cost-benefit analysis. I know you can probably give an example of...
Well, so it's to say all of their decisions and the things that they even tell you are driven by their emotions, and so it's hard for them to separate, what is actually the reality in the situation as from what they expect the outcome to be. So those situations are really hard to manage your client's expectations in a situation like that.
Yeah, and I think that brings up kind of an interesting point of, we've talked on many shows about managing clients' expectations. The other thing is, I think when a client comes in and talks to an attorney, they need to understand that they should be looking for an attorney that isn't just going to say, you're exactly right, let's go sue the guy or the gal, to where it's the whole thing of, there's so many different things that an attorney can do prior to litigation to try and resolve the issue and heal both parties, really. And I think that that's something that, we see so much of this stuff on TV, this lawsuit or that lawsuit. Every legal show shows a lawsuit, and I think there's a huge misconception that, okay, well, I'm immediately going to go into this attorney and we're going to file suit because I know that that's what we need to do.
Just because you met with the attorney?
Yeah.
As a younger attorney, I was guilty of, you had to put food on the table. And someone came in with a very simple case. This person owes me $700. Well, to file in general sessions is $100. So I mean, there's once you start doing an hourly rate onto that, you're really doing your client a disservice if you don't sit down and have a frank discussion about a cost-benefit analysis. And it's hard to make somebody that is passionate, that is upset, understand you're going to spend $3,000 to try and make $500.
I mean, even in the situation you're describing, when the client could be right, they're owed the money, they were wronged, and there was a disservice. But if the client, they don't understand all of the other things that go along with it, that it takes. You can't just go in and just get their money back.
And small businesses, I find, are guilty of that often, because the law in Tennessee says if you're a small business, if you're an LLC, you cannot represent yourself. You have to have an attorney. So if you're a small business trying to collect from a debtor or a client, it may not be worth your while to go after it. So I would caution or advise folks to have a frank discussion with their attorney about, realistically, what is the cost-benefit analysis of going down this road.
Yeah, and that's one thing. A lot of times in initial consultations, we get a lot of the emotion and what's going on, and it gives the client an opportunity to vent, certainly. But the other thing is we do a good job in our office, as I'm sure you do, Bill, of bringing folks back to reality and saying, hey, I understand you're angry, you're upset, but this is what it's going to cost, and do you want to go down that road? And maybe we can try something that won't cost as much, or some other alternative to that. And I guess when we return, we'll continue our discussion about common mistakes made by clients. Please stay with us.